understanding of whether or not an assistant principal gets involved here. I mean, in this case, we do have, this one's executed by Ryan Ridenour, so the PPAC will determine, the credibility of that testimony on its own. But I'm just, again, this is one of the two individuals we know of that actually met with the students face to face, heard exactly the allegations from them. And I'm trying to understand from her, another assistant principal, whether or not she was appropriate to provide direction to the teacher who's being alleged to have uncomfortable contact with the students, and whether or not you thought that was appropriate.
She testified that she's never issued a letter of direction. She doesn't know what a typical letter of direction looks like. She said that is always handled by the principal and HR. So whether her weighing in with her opinion is irrelevant, she doesn't have the experience.
I'm going to overrule the objection. The witness will answer.
I can probably simplify it, so I will rephrase. So based upon your interviews with that students, do you think it was appropriate to give guidance to Mr. Power, either through a letter of direction or otherwise, that, hey, it's appropriate to touch students so long as it's XYZ?
Objection.
Not even, I made it broader. I wasn't even referring to the letter of direction. I said, yep, through the letter of direction or otherwise.
Overruled. Please answer.
In my opinion, I think it is probably could be worded differently, but I know that it was guided not by Ryan Ridenour, it was guided by HR. I think that the reason it's in here is because when we are dealing with certain, I'm going to use my daughter as an example, in volleyball, she's a libero. She has to have a certain plane and a certain way that she holds her arms. And so the coach might come and grab her arms to put them in place to show how she should be standing in order to be able to hit the ball properly. So there are some times that students are redirected in that manner. So I believe that that was why this is in here.
Okay, and Mr. Power, he was not a volleyball coach, is that right?
No, but he was a stage and theater coach and teacher. And so blocking and stationing students might be a part of what they're doing. If they're in danger in the tech room where there are dangerous items, if he's moving them out of the way, I mean, that could be something that happened.
Okay, and I just want to be absolutely clear on this point, though. I know you're testifying that I know Ryan was guided by the principal and the superintendent or the district's office, but again, to be clear, in this specific circumstance, the 2022 complaints involving Mr. Power, you had no involvement other than just interviewing those two students, correct?
Interviewing those two students and the conversation that they had with the gentleman in the room afterwards. That was it.
And you were not a part or heard discussions amongst Mr. Ridenour and others at the school and district about what disciplinary action we should take in response to these complaints?
Disciplinary action, no.
Okay. You were not otherwise involved in whether or not we should go forward with a letter of direction, those discussions between Mr. Ridenour and other members of the school administration or the district?
No.
Okay. So as an assistant principal, if you have reason to be concerned that a teacher is a danger to a student's health or safety, what is your understanding of what you are supposed to do?
I report that to my principal.
Well, anything else you can do in response to those type of statements made from a student?
I mean, you report it to a principal and then you get direction and go from there. That's the process.
Well,
Principal handles personnel matters that go to HR.
okay, well, I can be more specific. As an assistant principal, do you have authority to visit the classroom of where the student is sharing that this uncomfortable behavior is occurring and observe what's going on in that classroom?
Yes.
As an assistant principal, have you ever attended a classroom to observe student and teacher interactions?
Yes.
And so again, those are things an assistant principal has authority to do.
Yes.
And I want to touch briefly on, you testified a bit about services that you believed were provided or offered to the students, or at least one student involved in the February 2022 complaints. Is that correct?
Yes.
All right. And I just want to be clear, did you ever personally offer services to student one or any of the students involved in the February 2022 complaints?
No.
How about Mr. Ridenauer? Did you ever observe Mr. Ridenauer taking that type of action to ensure the students receive services?
No, I did not observe that.
Okay. Have you ever-
Council, are we in 2022 or 2021?
I keep messing it up. I'm intending every time I'm saying 2022 here, I'm referring to those 5 complaints in February of 2021. So
Thank you.
sorry for mixing that up. Thank you for clarifying. And then have you ever heard of whether Mr. Ridenauer took any steps to ensure that the students he interviewed in February 2021 received services like mental health services?
I do not know that.
No further questions.
Thank you. Redirect. Mr. Enger?
Do you know roughly, and I'm just looking for an approximation here, about how many individuals are employed by the district?
Oh. The word, how do I say, 3,000 to 5,000?
Okay. And is the SRO an employee of the district?
No.
Do you know why Officer Lyons' name might not appear in Dr. Falloon's notes?
Because he wouldn't have been included in the meeting, because we wouldn't just always have an SRO in on a student issue because of anonymity and whatnot. We would only bring him in if it deemed necessary. And so they were having a meeting to discuss it. And in that meeting, information came up, at which point they would have brought him in. So he wouldn't have necessarily been on that meeting notice, because it wasn't, they were diving into it to see what would happen. And then within diving into it, the SRO gets called in.
Do SROs have school email addresses? If you know.
That's a good question. I would think they do, like our substitutes do. So I think they do.
Okay. So I'm going to have you turn to Exhibit 23 in the book.
Page.
I will, and I'm looking at Ridenauer 0096. In that third paragraph that you testified about earlier, let me know when you're there.
Yes, I'm there.
It says at the end of the interview, do you see that paragraph?
Oh, yes.
Do you see that?
Yes.
Okay. It says, at the end of my interview with Officer Lyons, he asked to look at the timeline provided by Mr. Redacted. Officer Lyons stated he remembered the meeting mentioned in the timeline and reiterated they, school officials, did not mention names or specific allegations. He was under the belief they were looking into it and would get back to him with something criminal, if something criminal or serious was disclosed. Did I read that right?
Yes.
So Officer Lyons acknowledges he was in the meeting, correct?
Correct.
Okay. And I'm going to turn your attention just back one page to Ridenauer 0095. The very first couple of words there says on August 18th, 2022. Do you see that?
Yes.
Okay, then turning to the next page, Ridenauer 0096. First full paragraph on that page says on October 12th, 2022. Do you see that?
Yes.
So this appears to be an investigation and interviews that took place a little more than a year and a half after the actual meeting took place. Isn't that right?
Correct.
Okay. And testified already, Officer Lyons is a sworn police officer. Is that right?
Yes.
And in your experience, are law enforcement officers allowed to ask follow-up questions if they have questions?
Yes.
Okay. And just in your experience, has Officer Lyons ever asked you a follow-up question when you've dealt with him?
Yes.
So during this February 11th, 2021 meeting, even if specifics, let's just entertain the idea that specifics weren't discussed, despite the fact that Dr. Flynn's notes say otherwise. Officer Lyons could have asked follow-up questions.
Yes,
Officer Lyons could have asked, who are we talking about?
yes,
Officer Lyons could have asked, are we talking about students?
yes,
Officer Lyons could have asked, what conduct are we talking about?
yes.
Okay. And just remind me, and I don't know if you've testified to this yet specifically, but what was the specific purpose of you meeting with the students?
I was a female, and they wanted a female administrator to be in there to give them a different perspective, give the students an opportunity to have a different soundboard, and to really make sure that they had everything that they needed from these students to move forward.
Okay. And you were asked about Exhibit 5. Could you please turn to that page? And it's Ridenhour 0044.
Yes, I'm there.
So I'm looking at those notes at the very bottom. Last in class, do you see that?
Yes,
So it says last in class, student 3 was outside waiting for me. Did I read that right?
yes,
Is it possible for a student to be outside a classroom and looking into a classroom?
yes,
So you also testified that you were involved in the meeting after meeting with the students for about 15 or so minutes. Is that right?
yes,
Okay. And is it your impression that the meeting continued between Dr. Falloon, Mr. Phillips, Mr. Ridenhour, and Officer Lyons after you left the meeting?
yes, because I was the only one that left at that point.
Okay. You were also asked about the letter of direction and whether or not you thought it was appropriate. Do you recall it?
Yes,
Okay. So I'm going to actually have you turn to Exhibit 20. And I'm looking at Ridenhour 0087. Let me know when you're there.
I'm there.
Okay, so there's a line that starts with an unnamed student. Do you see that?
Yes,
Okay, beyond that sentence, there's a sentence that starts with Patrick said. Do you see that?
yes,
All right, I'm just going to read it for you. It says, Patrick said the school told him to teach from behind his desk and not interact with students while they were at their desks. Did I read that right?
yes,
Okay. So Mr. Power's impression of his meeting and the letter of direction from that meeting appears to be teach from behind your desk. Is that right?
yes,
These February witness statements that you were involved in, was there anything going on at the district around that period of time?
Foundation.
It's a pretty broad question. Do you mean sports events? Sustained.
Was the district teaching in person during the entirety of the 2020 to 2021 school year?
no,
Okay. To the best of your recollection, when did the school return from remote to in-person instruction?
okay. So in the 2020, 2021 school year in Chandler, we returned remotely. So teachers were on campus for the first quarter. Students came back for the second quarter, which would have been in October. Then we had break, and I can't remember exactly when, but when we came back for third quarter, we shut down for, I think it was another 2 weeks and went remote because there was an influx of COVID that year. So there was another few weeks where we were off campus or students were off campus during this third quarter. And then we came back and remained open for the remainder of the year, or in person, the remainder of that year.
Okay, so tell me about your experience as an assistant principal during that entire process.
Relevance.
We are talking about a significant global pandemic. If there is something that the PPAC should consider related to an assistant principal's duties and responsibilities above and beyond what is in their specific job description, that is something that should be considered by the PPAC.
And
How
bring
does
up-
it relate to this case?
because assistant principals, as I would expect the witness to testify to, had other duties and responsibilities beyond just what is in their typical job assignments during a global pandemic. The witness just testified about closing and reopening. I'd like to hear, I think the PPAC should hear about the testimony related to what that experience was like and what else assistant principals and other administrators in the district were dealing with at that period of time.
Mr. Narlock?
I'm unable to comprehend how a pandemic relates to allegations of a teacher inappropriately touching students. And we already had Mr. Ridenauer testify, and I didn't hear him mention one time or at all that how the pandemic had any relevance on his mindset, on the abilities that he had to take actions or not take actions. So I just don't see the relevance in anything about the pandemic in this case.
And that's actually incorrect. Mr. Ridenauer testified about the contacting students, what his typical process was, and an explanation of why he wasn't able to potentially contact some of the students, because if someone was exposed to COVID, there was a waiting period where they were basically removed from school, required to quarantine, and then come back to campus.
Okay.
I don't think it's any secret.
I get the relevance of Mr. Ridenauer's testimony on that. I'm going to sustain the objection.
Okay. That is everything that I've got for this witness. Thank you.
All right. It's now time for questions from the committee or myself if they have one. I just have one. I think it's a yes or no question. Were you personally uncomfortable or comfortable? Let me try again. Were you personally comfortable with leaving Mr. Powers in the classroom after you talked to the two students?
Was I personally comfortable leaving him in the classroom? I guess I'm going to be honest. I did my portion of that, and then I left it in the hands of my administrator. So I
Yes or
didn't
no?
think about that.
It's a yes or no
I
question.
think you're asking me a yes or no on something from 5 years ago that I now have there's further information about that. I was called in to do one specific thing, talk to students, and then I was no longer involved. So I wasn't immersed in that to be able to say yes or no to you, ma'am. Sorry.
You knew that students were being touched by a male teacher.
And I knew
Junior
that
high students, let me finish. Junior high students were being touched by a male teacher. Were you comfortable with him continuing to teach?
I wouldn't have been comfortable in not looking into it, but it was being looked into by HR and my principal.
Are there any questions from the committee? Yes.
I have two questions in the same vein, though, I think. Thank you for being here first. In your experience as a teacher, as a counselor, and even the short time as a dean, could you classify Mr. Powers' behavior as inappropriate?
Inappropriate. Yes, I could classify it as inappropriate.
And in the 20 or 30 minutes that you spent with the two students gathering information, could you assess that they felt that what happened to them was inappropriate?
Yes. And I think we testified to that before prior. Sorry, you didn't have that, but yes. Mhm.
Thanks.
Other questions from the committee? Thank you, Ms. Telton.
Yes.
Yes. Mr. Ambos.
Was whoever Mr. Powers' evaluator ever brought into the loop for additional information in regards to observations, walkthroughs, or get them up to speed as to what was going on?
That part I don't know.
My next question. You as an assistant principal, do you have the opportunity to express your opinions, concerns about something that is decided by your superiors that you can, for lack of a better term, push back? And I know you said that you didn't have a lot of experience with letters of direction or reprimand, and good for you in that you don't have to do that on a regular basis. But do you have that avenue to voice your concerns, to say, not really comfortable with this?
I can voice that to my principal. I feel like maybe that avenue isn't always open beyond certain levels. for assistant principals. So we can voice to some extent. But there, we can voice I voice my opinions to my principal.
Further questions? Okay, you're excused as a witness. Thank you for your testimony. We're going to take a 5-minute, 6-minute break. Let's try to be back at 11:55.
We're live.
Mr. Anger, please call your next witness.
Thank you, hearing officer Lee. Respondent calls Garnett Burns.
Hearing Officer Lee, I have I guess an objection and a question. Ms. Burns was subpoenaed previously by counsel, and as I understand it, you had quashed that subpoena, making a determination that her testimony would not be relevant. I think at a minimum, we would need some sort of offer of proof as to what has changed.
Hearing officer Lee, that was due to unavailability. That was the primary reason why you quashed the subpoena, and now Ms. Burns is here voluntarily. The rules specifically require that a respondent be afforded the opportunity to call witnesses and present evidence, and we're calling the witness that is here under her own accord.
Could you provide me with a copy of my order?
I do not have a copy of your order. I can obtain one. Again, I think the order, though, was directly related to the subpoena and the witness's unavailability. Now we don't need a subpoena because the witness is here.
Forgive me, but I don't have the recollection of exactly what I wrote, Mr. Anger. So I'm going to need some prompting from you.
John, you have Wi-Fi. Thank you.
Hearing Officer Lee, I do have a copy. I have it electronically, but I can read the section in your ruling. Actually, I'm going to look off of Ms. Burns'
Mr.
computer 'cause
Anger,
I
do you
can't
have any
read it.
objection to him reading it to me?
No.
Okay.
And yeah. Let me just tell you the date of this. Why is that not helping me? Yeah, actually saw it. There you go. Okay, this is your order dated the 14th of October. And specifically go up one. Sorry, Michael, is that the same one?
No, this is it.
Oh. Get the one back on your phone. I apologize. We're not looking at the same order, but we do have the order that.
This one's actually.
Okay, so it's the order dated October 13th. And if you'll bear with my eyesight, this is the third to last paragraph. You're discussing the subpoenas to Director Burns and to Chief Spellich. And you write, Deputy Director Burns had no inkling that she would be called as a witness for the October 15th, 2025 hearing, and accordingly made plans to present at the NASDAQ conference in Minnesota without information as to why Director Burns' testimony is essential to respondent. Sorry.
Do you want him to start over?
Sure. Deputy Director Burns had no inkling she would be called as a witness for the October 15th, 2025 hearing, and accordingly made plans to present at the NASDAQ conference in Minnesota without information as to why Director Burns' testimony is essential to respondent. Her subpoena is quashed. And just editorial comment, I think that reflects your overall finding that they had not provided a sufficient reason for the need for the testimony.
So I guess one of the questions I have is, if you don't provide the reason for a subpoena, can you now call a witness without providing that?
Hearing officer Lee, if I may,
Sure.
And this is the evidence that is presented in these contested cases. I'm looking at R7-2-715. It says all parties shall have the right to present such oral and documentary evidence and to conduct such cross-examinations as may be required for full and fair disclosure of the facts. It's a right that's afforded to present evidence. She's listed, Ms. Burns is listed on our notice of witnesses and exhibits. You quashed a subpoena because she had a prearranged travel that you thought it was unfair for her to have to cancel those plans. But we're not talking about a subpoena anymore. We're talking about a witness that is sitting in the room that I would like to call as a witness.
But it hasn't changed that I have no idea why you want her.
And I'm not asking for you to make any determinations about whether or not the questions that I'm going to ask are relevant. The state will have the opportunity to object to any questions that I ask based on grounds of relevancy. The hearing officer can sustain or not sustain those objections. But I think at a minimum, the witness is in the room. We don't have a travel issue related anymore. Rules identify that the party has the right to present evidence through documents and testimony and cross-examine. Ms. Burns is the representative of the state. The respondent is asking to call the representative of the state as a witness in the hearing against him. And to go further, I only expect to ask maybe 10 minutes of questions. So I do not expect this to be a lengthy examination.
So are you refusing to present an offer of proof?
I don't think I need to. I think the rule says that I shall be allowed.
So that'd be a yes.
Yes, I don't think it's contemplated by the rules.
Mr. Richards,
Well, that's what I was asking for was, I don't think it's too much to ask if he's only got 10 minutes worth of questions. And we're now being, we were told for the first time yesterday evening or late in the day that they might be interested in calling Ms. Burns, and I still don't know what they're calling her about. And I think that given the circumstances, it's appropriate for them to fence themselves in at least by saying this is what she's going to be testifying about, and let us talk about whether or not that's going to be relevant at all, that subject matter.
I have to tell you, Mr. Enger, it's the first time I've quashed a subpoena and then been presented with a request to call the same witness that I quashed. I agreed that we're kind of off the subpoena subject.
And this is a bit of an unusual case, given that we're running into a second day, a month after the initial hearing, and after the witness has returned from her travels.
I still want to know why you're calling her.
Yeah, and so I will only be asking her about a document that has already been admitted into evidence.
Which
And,
one?
It'll be the presentation that has her name on it. That is all I'm going to ask her about, and her basic background.
You're going to have to help me out a little more.
Yeah.
This what? Slides. Oh, I'm sorry. The vice chairman has just enlightened me that it's the slides.
That's right. Exhibit E.
So it's the training.
That's right. Which has already been admitted into evidence. So it's already, any objections to the relevancy of the document's already been waived. Her name is on the document. I just want to ask her a couple of questions about the document that's already been admitted into evidence.
All right, I'm going to allow it. Ms.
Thank you.
Burns, please take the witness stand. Please raise your right hand. Do you solemnly swear to tell the truth and nothing but the truth in today's proceeding?
I do.
Thank you. Please proceed.
Good afternoon, Ms.
Mike.
Thank you. Good afternoon, Ms. Burns.
Good afternoon.
Do you mind if I refer to you as Ms. Burns?
No, that's fine.
Can you tell me what your title is?
I'm the Director of Enforcement Actions,
Okay, and what is the name of your employer?
State Board of Education.
Okay, and just describe for me your general duties and responsibilities.
My general duties are to oversee the enforcement action portion of the board's workload, meaning educator discipline after investigation is completed.
Can you please turn to Exhibit E in the binder in front of you? And
E as in Edward.
E is in Edward. And I've got two different Bates numbers on this document, so I'm not sure which one It is, but it is the one with Ridenhour 00052 and Ridenhour 00093. And this should be in respondents exhibits.
First one is 0042. Was that correct?
I believe the first page with the exhibit page is Ridenhour 0029.
Okay,
You with me?
0029, yeah.
Yes. Okay. Can you please turn to Ridenhour 0053?
Yes,
And do you see your name on that page?
yes,
Okay. And let's go back to the first page of the document, well, page after the first page, to Ridenhour 0030.
okay.
And it looks like this is a PowerPoint presentation of some sort. Can you just describe for me what this is?
This is a PowerPoint that was created specifically for a charter school that requested training due to an incident they had in their classroom, and they wanted a refresher for their teachers and administrators on mandatory reporting.
Okay. And is this generally available on the state board's website?
Yes.
Okay. And are there any differences in terms of reporting obligations at charter schools as opposed to school districts?
No,
Generally not.
generally not.
Okay. Can you please turn to Ridenhour 0051? Let me know when you're there.
I'm ready.
Okay. So the title of this page is Report to DCS, Law Enforcement, or the Investigative Unit, question mark, question mark. Did I read that right?
Yes.
Okay, can you just read that scenario in that sort of the middle of the slide there? It starts with a teacher.
That whole paragraph?
Yes, please.
A teacher has received progressive discipline for 2 previous incidents involving inappropriate language and inappropriate behavior in the form of outbursts, both physical, slapping hands on the desk, jumping around in front of the class, and verbal, due to frustration with the students, quote unquote, not listening. Progressive discipline was implemented and the teacher is then terminated after incident number 3, in which students were leaving the class without permission. You want me to keep going?
No, that's
Okay.
sufficient. Okay. And then the first bullet point under that says investigative unit would take this report if it qualifies under ARS 15-514F.
Correct.
Did I read that right? What does that mean, would take this report?
That means it would be in our jurisdiction. So they could report it either way, but it would be accepted by the unit as a valid complaint.
Okay, so does the state board then also have discretion to reject a complaint?
They do.
And just,
Well, they don't reject a complaint. We accept all complaints, then we determine whether we have the jurisdiction, if it falls in our jurisdiction, and then we'll investigate. So we investigate all complaints, at least at a basic level, before determining how to move forward with them.
okay, so how do you determine whether or not something is within the state board's jurisdiction?
We review statutory language. For instance, a non-certified educator. There's certain criteria that a non-certified educator has to meet for us to be able to have the ability to take action. If we don't have the ability to take action and they don't fit within that criteria, we would not then do a full investigation. We would send a letter saying that it's not within our jurisdiction.
Okay. So the bullet under the reference to 15-514F says, did the teacher engage in immoral or unprofessional behavior? I apologize. Listed in Arizona Administrative Code R7-2-1308. The answer is yes, it must be reported to the IU. Did I read that right?
Correct.
Okay, and that's in relation to ARS 15-514F, correct? Okay, and if you know, does ARS 15-514F discuss separation of the employee?
No, actually, it would be, I think it's 514B that would fall under, not F. It's B or C. F is the, actually, I don't have it in front of me.
Yeah, and it's, we've got it here, so we can reference it. Just give me a moment to find it. While I'm looking for that, would you agree with me that these bullet points are in direct relation to the hypothetical above it?
Correct, yes.
Okay,
that bullet point would fit under B, I believe, 514B.
514B, got it. Okay, so let's take a break. Just if you could mark that page with something, I can give you a pen or something if you want to throw it in there, because we're going to go back to
Here we
it.
go. I got it.
It's good improvisation. We're going to go to Exhibit F.
Okay.
Okay, so this is right now 00055. Do you see that?
Yes.
Okay. So F reads, a governing board or school district employee who has control over personnel decisions and who reasonably suspects or receives a reasonable allegation that a person certificated by the State Board of Education or a non-certificated person has engaged in conduct involving minors that would be subject to the reporting requirements of section 133620. And this article shall not accept the resignation of the certificate holder or non-certificated person until these suspicions or allegations have been reported to the State Board of Education. Did I read that right?
Yes.
Okay. And would you agree with me that Mr. Ridenhour is not an individual that had control over Mr. Powers' personnel decisions?
Yes.
Okay.
Sorry. Yeah.
And let's look at B that you are referencing.
Okay.
I'm going to just read it for you slowly. The superintendent of a school district or the chief administrator of a charter school who reasonably suspects or receives a reasonable allegation that an act of immoral or unprofessional conduct that would constitute grounds for dismissal or criminal charges by a certificated or non-certificated person has occurred shall report the conduct to the State Board of Education. Did I read that right?
Yes.
Would you agree with me that Mr. Ridenhour is not the superintendent of Chandler Unified School District?
I would.
And would you agree with me that he was not the superintendent of Chandler Unified School District at the time?
I would.
Okay, so let's go back to that page we were discussing earlier. The third bullet point under that hypothetical says, did the teacher engage in behavior that directly resulted in his termination? If yes, it must be reported to the investigation unit. Did I read that right?
Yes.
Okay. The fourth bullet point is, did the teacher engage in behavior that could result in criminal charges? If yes, it must be reported to the investigation unit. Did I read
Yeah.
that right? Okay. And this slide, we're going to go back to the hypothetical. This slide allows for progressive discipline. Is that right? It contemplates it,
Yes.
correct? And this slide doesn't say that an educator has to report to the investigative unit while the teacher is going through the progressive steps of discipline, does it?
No.
Okay. That's all I've got for this witness.
Any cross-examination for this witness?
No questions.
Thank you. Oh, does the committee have questions for this witness? And I don't have any. Thank you for testifying, Ms. Burns. You're excused as witness. Do you have more witnesses?
Those are all the witnesses that I've got, Hearing Officer Lee. So I might suggest if you want to take a lunch break and we can come back and do closing.
You want to keep going, everyone? Or do you want to break? Keep going? Yeah. All right, let's have closing.
One minute. Situated.
Certainly.
Apologize for cracking open my can. We don't have water. Okay. May
Please
I
proceed.
Thank you. Hearing Officer Lee and members of the committee,
we have reached the point now where the case is in the committee's hands, and you will be making your decisions on the issues that are actually at issue in this case. The most that we can do as the attorneys is, number one, highlight what those issues are, help to explain them if they need explanation, and offer some commentary on and observations on the evidence that you received that relates to, or perhaps doesn't help you make your decisions on those issues. So what are the issues here? Well, the evidence in this case that you have heard, the testimony, the exhibits, all of it together shows you that this case is all about protection of students. It's all about determining the responsibilities of a senior, well-experienced, sophisticated assistant principal at a large, sophisticated school district when they are faced with allegations from multiple students ranging in ages from 12 to 13 that a teacher has for months been touching them inappropriately in a number of different ways in their classroom, whether by rubbing up and down on their backs, making the female students come forward with their exams and forcing them to hug him as they do, grabbing students around their shoulders and pulling them in when he's simply answering questions for them, grabbing one student so tightly that she felt that she had to pull herself away from him, touching students on the legs on a regular basis, on a weekly basis, student one explained. All of those things, when receiving that information and receiving information, names of some 10 other students who may have other experiences themselves with the same teacher, the same type of experiences. What are they expected to do? How are they expected to behave? And what does the state require of them? There are two regulations at issue here. They both go to the same issue. The first one is R7-2-1308A1, which states very clearly that individuals holding certificates issued by the board shall make reasonable efforts to protect pupils from conditions harmful to learning, health, or safety. It's not a may, it's not a should or could, it is a shall. It's mandatory. Your decision-making here obviously requires you to see whether or not the state has established all of the elements that indicate that Mr. Ridenour did not uphold that obligation, that he did not make reasonable efforts that were available to him to protect pupils from conditions harmful to learning, health, or safety. The first question is, were there conditions potentially harmful to learning, health, or safety? Let me go over the evidence on that point. And I'm going to try not to just belabor all this or reread statements to you because you've seen it all and some of it you've seen multiple times. But to summarize it, you had evidence that Mr. Ridenour was the point of contact for the first 5 students. Mr. Ridenour not only took statements from the students, but he had them prepare written statements for him in their handwriting in his office. He was assigned responsibility for conducting that investigation. This wasn't something where he, like Ms. Woodworth, was called in and, told, well, just go talk to this one student or that other student. He was given that responsibility to do the investigation. You've seen what he was told. You've seen he was told by various students that, number one, this was happening over and over again in Mr. Power's classrooms, and it was making students upset. You saw that student 2 had said in her statement that Mr. Power was scary. You saw that student number 3 had explained how she had observed student number 4 being touched and how student number 4 had expressed how upset she was and that she wanted to drop out of his class because of that. And you saw that student 3 told Mr. Ridenour, I did drop out because I saw this happening to other girls and I didn't want it to happen to me. You had other evidence from students 4 and students 5 that covered similar types of incidents, including the one that Mr. Narlock used with Ms. Woodworth today, that talked about this embrace happening while the student was the last student in the classroom. Clearly, we submit that there is lots of evidence from which you can find that there were conditions presented to Mr. Ridenhour that were harmful to the learning environment. When students are dropping out of class, when students are expressing that they're fearful, when a student breaks into tears at the mention of Mr. Power's name, when she's called in to talk to Mr. Ridenhour, plenty of evidence that there were conditions harmful to the learning environment. We can go further with health or safety. We can talk first about mental health. Mr. Ridenhour knew that students were upset. He knew that students found he saw from the statements he got verbally and in writing that students felt that this was oppressive, that it was scary, that it upset them emotionally. It frightened them so much so that student 3 dropped out of his class. And you saw that this had been going on. And Mr. Ridenhour saw this had been going on for months. It didn't just happen because he got the text messages. You'll recall with 2 of the students, either the parent or the student gave him the text messages that they had been exchanging with classmates months before they ever reported to him, which expressed the same concerns, the same fact that they found Mr. Power to be creepy, that they were upset by what was happening. And you heard Ms. Woodworth's testimony today, where she acknowledged students can be harmed by that. Conditions harmful to mental health, that evidence is here. Conditions harmful to safety of the students. Now, this is one in which you've heard some interesting testimony from Mr. Ridenhour and from Ms. Woodworth, who now claim to you to apparently understand all about grooming behavior because of a class that they took this summer, just this summer, not back here, but just this summer. And that they understand it's really not a danger if it happens in public. It's really not something to worry about if it happens to a lot of students versus a single student. If no one is culled out, if no one is separated from everybody, then there's not grooming going on. There's not something to be worried about. I would submit to you that as superintendent, as parents, as teachers, principals, that you could reasonably be very concerned and maybe even more concerned with the teacher who does this in public, who does this over and over again to multiple victims of his touching, of his unwanted touching, who is not afraid to be doing this openly on a regular basis, and who, as we now know, was so unconcerned that even after he received his letter of direction, he kept it up, now with older students. And you saw that within a few weeks of that, there were more reports coming in from 17-year-old students. He was engaging in the same conduct with them and even more. He was appearing frequently at one of their places of work. He was inviting them to go to this technical gun show and give them tickets to it with him over the weekend. Again, you'll use your own experience. You have probably seen the worst of the worst. You have been exposed just simply as adults, unfortunately, living in a world and in a community that, you know, we live in large communities, and we read about bad things happening, but you may all have seen it actually up close and personal. To suggest that, gee, this gentleman who was frightening the students was doing it in public. He was doing it to lots of girls. Therefore, there was no danger. I submit you could have a very different reaction to that. You have a very different thought about that. And frankly, given what we know about Mr. Power and what happened after, you'd be right. You'd be justified. There was definitely conditions harmful to student safety. So then the question becomes, well, what was done? What did Mr. Ridenhour do and what did Mr. Ridenhour not do? Because what he was required to do by law, he was required to take reasonable efforts to protect those pupils. Now, what Mr. Ridenhour suggests is, well, yeah, nothing was really my responsibility. Those decisions are made higher up the command chain. That's my principal. That's the district officials that make those decisions. I don't make those decisions. I don't have that authority. I can't really do anything. I would ask that you think about what you actually saw happen here, what you heard even this morning. Mr. Ridenhour was at the center of this issue. Mr. Ridenhour was responsible for the investigation. Mr. Ridenhour knew personally that not only had he received those statements, the emotion, the breakdown, had he got all that from just 5 students, he knew there were 10 other students out there that had been listed as other potential witnesses to the same thing. But Mr. Ridenhour did nothing about those other 10. He's acknowledged, he stopped. He didn't do any further investigation. He didn't find out who else might be in danger, who else might be in trouble, who else might be upset, who else might need counseling. Now, what he said was, well, our normal practice was to contact these people. And then you saw what he said when that was drilled down on. He told you he didn't actually have any knowledge that anyone actually attempted to ever contact any of those students. So this idea that, well, it was COVID and it was busy and people were in and out and they were suffering from disease, and you didn't hear any actual evidence of any of that, right? Nothing. What you heard is him acknowledge he had no knowledge whatsoever that anyone had actually tried to reach out to any of those people. So all you have is you have an assistant principal who is experienced, who is trained, knows what he's doing, and he has 10 students out there that have been listed on top of everything else that he's heard personally firsthand, and he chooses not to look any further. State submits that is definitely not taking reasonable efforts to protect your pupils from these type of dangers. You also saw that Mr. Ridenhour was not simply a cog in the wheel. Mr. Ridenhour was part of a consensus team making the decision about what to do with Mr. Power. You heard it from his own testimony. He was there and present. Unlike Ms. Woodworth, who says she left, she admits he was still there, and he was still there. He testified to you that he was the one who actually drafted that letter of direction. He was the original author of that. He sent it to Dr. Falloon at the district office, who edited some, but it was his original work. It wasn't someone else's. He was also assigned to sign it. He put his name to that. He gave the direction. He was required to have the meeting. He was required to execute on that decision that what we're going to do here is just give this letter. And I think his suggestion to you is that, seems to be that, well, that's all I had to do. That was enough because anything else would be someone else's authority, someone else's responsibility. But you've heard from Mr. Ridenhour himself what else he could do. And you just heard from Ms. Woodworth, co-assistant principal, what else could be done. In fact, even in response, I believe, to some of your questions, Mr. Ridenhour had every opportunity, every bit of authority to follow up on that letter, to go visit the classroom, to observe and monitor that teacher, to ensure that any directive that had been given was being followed to the letter, to ensure that there was nothing going on that needed further direction. That's the minimum. That is the minimum. Some of you may be thinking, you know, what was done the next time they got a report about him, which was preparing that administrative leave letter that you're gone, you're not going to be here on campus anymore, that was the thing, or the right thing to do. But at a minimum, Mr. Ridenhour had the authority and the responsibility to follow up. And we asked him, did you do any monitoring? Did you do any training yourself of this individual? Did you do any follow-up? Were you in his classroom to observe his actual interactions with the students after you gave him that letter? You heard what he tried to do, right? What he tried to say was, well, I had a volleyball coach that shared that space. And I remember being in that classroom area lots of times. There were tryouts going on for volleyball, and I remember going down there. But when he was pressed about whether he ever went down there, whether he could identify a single day, a single class session that he stepped into after he handed that letter off, where he actually went to observe anything involving Mr. Power, his answer was no, I can't. He apparently, what he's told you is he had plenty of time to walk around and talk to the volleyball coach about how the tryouts were going. But he had no interest, took no actions to step into a classroom where he knew a teacher was imposing himself physically on 12 and 13-year-olds. No interest in doing that. And he didn't do it. And he told you himself, he can't testify to you a single time that he stepped in there to do any such thing. Even though Ms. Woodworth has told you, they could do that all the time, that any assistant principal had that authority. And that's what we would expect. Was what we would expect generally from someone who has that kind of authority at a district, particularly a sophisticated district like this one. You also heard all the other things that didn't happen. You know that Mr. Ridenhour made no further efforts to communicate with Mr. Power about any of these issues. None. He's confessed he can't testify to you about anything he did in terms of providing further direction to Mr. Power, further follow-up. And then we talked about all the other things that weren't done, all the other things that are done frequently at that school and in that district for teachers that they're having problems with. We talked about mentoring, that they appoint mentors. We talked about putting people on administrative leave, that they do that. We talked about putting teachers on mandatory training plans. They do that. We talked about putting people in the classroom, which they could and can and do. In fact, you saw the letter that went out to the parents when they allowed Mr. Power to resign. That letter indicated that they had people, in fact, I think 2 people to put into that classroom at that time. Mr. Ridenhour didn't suggest that. He hasn't told you he suggested it. He hasn't told you he arranged it. He had full authority to recommend those things. He had full authority to be the person in the classroom himself. He didn't do any of it. Now, I suspect that you're going to hear that, well, Mr. Ridenhour wouldn't do those things because Mr. Ridenhour wasn't the person who could make the call. On some of those things. On some of those things, Mr. Ridenhour, he couldn't change staffing by himself. He couldn't appoint a mentor. He couldn't put someone on administrative leave. He couldn't do any of that because he was just an assistant principal. So I asked him a whole bunch of questions, and you heard his answers about advocating for those things, about raising his hand and saying, I think maybe we ought to do something more than just giving a letter to somebody that says that your behavior is borderline inappropriate. That's the language in that letter. It's borderline inappropriate. I'm not sure what that means, but it doesn't sound very serious. And I asked whether he raised his hand. I asked whether he advocated for something different. I asked whether all these things that he knew that they did where they had problems with teachers, if he advocated for any of those things, and you heard his answer. His answer was he couldn't recall ever doing that. He couldn't provide you a single example of his meetings with Dr. Falloon and with his principal where he ever advocated for any of those things. And you heard from Ms. Woodworth today. They can advocate. And I think you know that they should advocate. Again, perhaps the least that they can do, the least thing you can do that's a reasonable effort to protect pupils is to advocate for those pupils, to advocate for their protection. And he's admitted that he did none of that. You've received significant evidence of what happened as a result. And perhaps some of you may be thinking it's not much of a surprise that just several weeks after delivering this letter and then washing his hands of the issue, there were new complaints that had added elements to them regarding high school girls, high school students. And you saw the evidence of the additional fallout. And you know that Mr. Power, despite all of this, was allowed to retire, quote unquote, retire. The board wasn't told he was under investigation. The board wasn't told that they had simply, that Mr. Ridenour had, simply delivered this letter to him. It's a letter of direction that, by the way, actually said in it that he could continue in certain circumstances to touch everybody, all students in his class. Mr. Ridenour didn't give him any policies, procedures. He didn't testify to you that he gave him some sort of training to explain what that means, that he told him, okay, this is out of bounds and this is in bounds. He gave him a letter that simply said, there were examples, there were instances, there were ambiguous, open-ended issues, circumstances in which he could continue to touch students. That's what he was provided. This is a unique case in that we know the consequences of failing to take reasonable actions to protect your students. We know that there were more students affected. At least 2 more that came forward and reported on that. We know that a teacher that was involved in this type of activity was let loose with no mark on his record and went forward until he was confronted in a police station by not only the police officers that were investigating him, but by the investigator from the department who obtained his resignation, or his surrender of his certificate. None of that happened because of what the school did. None of that happened because of what Mr. Ridenour did. That happened because of what parents did. Parents who reported this issue to the police themselves. So you know what the consequences are here. They are clear. And let's talk about the police for just a moment, as we've all heard a lot about Officer Lines. One thing we didn't get is Officer Lines walking through that door and appearing here to testify for you. Wasn't here. Mr. Ridenour had the opportunity to call him. I think you heard in the first day of this hearing that they had attempted to serve a subpoena. It's been about a month since we were last here. Still not here. You heard simply testimony that suggests that somehow what exonerates everything here is that Officer Lines said something that made everyone think this is not a big deal. This is not really something we need to worry about. This is all okay. We can get away with just a letter of direction. But you saw what Officer Lines said twice when interviewed by other police officers. And it was very specific. And it directly contradicted statements that Mr. Ridenhour's made, statement that Ms. Woodworth made to you about this, some exonerating statement that Officer Lyons made. So that's what you have for evidence. Take that one step further, though. What if Officer Lyons had said, you know what? I'm going to do a full investigation into this myself. I'm going to go talk to people because I need to determine whether or not I need to go turn this in, potentially charge it as a crime. And he had come back and he had said, you know, I've done my investigation, separate criminal investigation, not your investigation, but I've decided that I am not going to forward this on for, you know, further investigation or charging. Respectfully, that doesn't change this. That doesn't change the obligations of the teachers, the administrators at the school to protect their pupils. It's a red herring. It's irrelevant. But I think you've seen the evidence. It's also untrue. And that's the last thing I want to talk to you about, which is the role of credibility in making your decisions. One of the really important things about having a system like this is that real people with real experience and, you know, folks that have dealt in the real world get to listen to people provide their testimony. And you get to measure that against how real people sound, how honest people sound, how people that are trying to hide something sound, how people who are trying to avoid something sound. You know, you've all been in positions where you've faced that yourself directly. And you know how people sound when they're telling the truth. They're being direct. You know what it means when somebody is asked a yes or no question and they don't answer yes or no. Instead, they give an explanation or an excuse. You know what that means. You know what it means when someone is asked a question about, Mr. Ridenhour is asked a question about, did you ever follow up with any of these 10 other students? Did you ever do any investigation there? And his answer, instead of saying, no, I didn't, which is the truth, he says, well, our standard practice was that we would always contact other people that were identified in any investigation, and someone would do that, and I'm sure that, you know, that's what we would have done here. It's not an answer. In fact, what is it? It's an attempt to get you to think that something happened. Something different happened than what actually happened. And then when we pressed him on it, when we put him under oath, under questioning, and said, did anyone ever actually do that? Do you have any information that indicates that anyone actually followed this standard procedure you're talking about? And then finally, he said, the truth. No, I don't have any of that. But you know what it means when someone is willing to sit here in front of you and suggest something to you, that something happened, when they have no earthly information that indicates that actually happened. You know what that indicates about their credibility, about their integrity, about their honesty with you. And that wasn't the only example here. You heard other examples. And you've got the example of, you know, Officer Lyons told us this, that, and the other thing, compared to what Officer Lyons actually was reported to have told the police officers multiple times. You've seen all that. You've heard it. I'm not going to belabor that, because each of you probably have other things that you picked up on individually that you sensed, this just doesn't sound right. I will tell you, go with your gut on that. Your instincts are good. I think it's fair that you use your common sense, your instincts on all of that. And the state submits, this was not the testimony of someone who is coming in here to tell you that even on reflection, they messed up. They didn't do what they were supposed to do. They didn't uphold their end of the bargain, their end of their obligation, their end of the privilege that they have to hold a license as an educator. It's not that type of testimony. You've heard that type of testimony before. And I submit that wasn't it. I'm going to just talk really briefly then about the last issue. The final issue is the requirement. This is in the shall not categories. The rules for certificated people say there's certain things they shall do, they must do, and there's certain things that they should never do, ever. In the shall not category is a certificate holder shall not engage in conduct which would discredit the teaching profession. Recognize that there's a lot of things that could fall into that bucket. I'm just going to suggest one way to think about that. Think about it from the perspective of the people that rely upon people like Mr. Ridenhour. The students that rely upon him to protect them. The parents that rely upon the people they've entrusted with their children's care, education during the day. The higher district officials who depend upon their administrators to do the right thing all the time, not just some of the time. There are a lot of folks whose perspectives are relevant here. And I'd suggest you could take any one of those perspectives, simply ask, is what Mr. Ridenhour did, is that what we expect people to do? Is that the type of responsibility that we expect them to show? Is that the type of sensitivity we expect them to demonstrate to an issue where we have somebody who is repeatedly touching, upsetting young female students? If your answer from any one of those perspectives is no, those people who rely upon people like Mr. Ridenhour, they'd be disappointed by that. They'd be upset by that. They'd find fault in that. Then you have a basis for finding a violation of 1308B15 as well. And the state submits that's been proven. Last thing, discipline. Obviously, it's your decision to make. If you find that, in fact, the state has established these violations, it's your decision to make on discipline. And in this particular case, there's a lot of factors to consider there. Obviously, we have someone here who their licenses, their certificates are suspended. I would submit to you that that is not relevant to your determination of discipline. Your determination should be made the same way you would make it for somebody who is sitting here before you with an active certificate, who's actively working in the system. I think that's the appropriate way to, or I submit to you, the state submits to you, that's the appropriate way to look at it. In addition, there's always a question about if there is discipline imposed, if there's a suspension, for example, imposed, is it concurrent or consecutive with the discipline that's already been imposed against Mr. Ridenhour? Basically what that means is it's like a kind of like in a criminal sentence where, you basically are serving your discipline at the same time, or you finish one and you start the other, and whether or not that's appropriate. It's fair consideration for you. State submits that in this particular case, it's most appropriate to consider the fact that these are different issues. These are different events. These are not the same thing. That what Mr. Ridenhour was disciplined for in his other case, it's not this situation. This situation stands on its own. This situation deserves appropriate discipline for this situation, whatever that is that you submit. And the state submits that a 3-year suspension to run not concurrently, but consecutively after his current suspension is finished is most appropriate. Thank you.
Thank you. Mr. Anger.
Hearing Officer Lee, members of the committee. Mr. Ridenhour and I appreciate your time and attention to this important case. As I mentioned in my opening, about a month ago, this matter has the attention of educators throughout the state. The consequences of the PPAC's decision today will surely reverberate throughout our state for a significant period of time. With respect to the allegations and the regulations at issue, I want to start with a very important point, which is we are not here again to talk about a mandatory duty to report. It's not what has been alleged. We're only here on the state's allegations that Mr. Ridenhour violated Arizona Administrative Code R7-2-1308A1 and R7-2-1308B15. They're on the whiteboard for you. A1 identifies that an educator shall make reasonable efforts. Noticeably absent from that provision is do anything and everything possible. It is reasonable efforts. B15 says that educators shall not engage in conduct that would discredit the teaching profession. I have a very different view of the evidence that's been presented to the committee throughout this case. And I'd like to discuss and walk through the evidence that I think the committee should consider in terms of the reasonable efforts that were made and how that it does not discredit the teaching profession. I want to start with the collecting of witness statements. If you recall Mr. Ridenhour's testimony, one witness statement was brought to him, and that was the witness statement of student 2. Mr. Ridenhour testified that was his normal practice to then contact the students that were identified in the written statement and collect written statements from them as well. We know that happened in this case because student 5's name is not included in the witness statement of student 2. Rather, student 5's name is only listed in the witness statement in student 1's written statement. And we obtained a written statement from student 5. So we know that Mr. Ridenhour contacted other students and brought them into his office to collect their written statements. This was not a situation where a group of students all came forward at once. Rather, one student came forward and Mr. Ridenhour collected other written statements from students that he could contact and call down to his office. The involvement of other administrators is the next thing that I would like the committee to consider. One of the questions posed to Mr. Ridenhour was, have you ever dealt with a situation where a teacher was touching a student and it made them uncomfortable? And his testimony was no. This was my first time. Mr. Ridenhour collected the written statements and then involved his supervisor, Mr. Phillips, the school's principal. After conferring with the school's principal, they decided it was a serious enough situation to involve the executive director of human resources with the district office, Dr. Falloon. They knew this was beyond something that they should handle in isolation. So Mr. Ridenhour involved the other professionals at the district as is appropriate. Involving the SRO is also a reasonable step that Mr. Ridenhour took. As you heard from Ms. Woodworth, the SRO was a sworn law enforcement officer. Mr. Ridenhour was included in the meeting where the SRO and the allegations against Mr. Power were discussed in specific detail. The inclusion of the SRO is a reasonable step. Mr. Ridenhour and Ms. Woodworth both testified that Officer Lyons was in the meeting. In addition, the Queen Creek Police Report also identifies and acknowledges that Officer Lyons was in the meeting. And then there's this question of, well, were there specifics discussed? We only need to look at Dr. Falloon's notes from that meeting to identify that indeed there were specifics that were discussed. The student's name, student one's name, was identified. The allegations that Ms. Woodworth was able to elicit from student one are specifically in Dr. Falloon's notes. Touches my legs weekly. He does it to everyone. Those are written in Dr. Falloon's notes during that meeting. And there was a question about reliability and what you should believe. I would submit to the committee that notes taken during a meeting are going to be significantly more reliable than an interview with a police department a year and a half after that meeting actually took place. Weighing that evidence should be a clear determination for the committee that these specifics were discussed. Involving the SRO in that conversation, again, is a reasonable step. At the end of the meeting, you heard Mr. Ridenour and Ms. Woodworth testify that Officer Lyons provided his opinion that there was nothing criminal for him to investigate. It turns out that was right. Presented to you as Exhibit B is the declined to prosecute letter from the Maricopa County Attorney's Office, where they declined to prosecute Mr. Power for any of the allegations that were alleged against him. Involving a female administrator is also a reasonable step. This morning, you heard Ms. Woodworth testify that the reason she got involved was because they wanted a female administrator to speak to one or more of the students. We have Mr. Phillips, a male, Dr. Falloon, a male, Mr. Ridenour, a male. Understandably, they may have thought, you know, these students may not feel comfortable speaking to a male if something more serious were to happen. Let's contact a female administrator and see if they'll be more forthcoming with a female administrator. You heard Ms. Woodworth testify that middle school wasn't even within her scope. She was with the high school, but she was the female administrator that was available to come over and speak with the students. Involving a female administrator to double back with the students and talk with them to determine whether or not there was anything more serious that should be considered is a reasonable step. Meeting with Mr. Power. In the letter of direction, which is the state's Exhibit 8, it identifies that, and I'm going to quote some language from the letter of direction for the committee, based on our conversation this morning. That is specific language from the letter of direction. If you'll recall Mr. Ridenour's testimony about that language, he testified that that morning he met with Mr. Power and said, "Why are you touching students at all?" Mr. Power explained to him, I have to teach them how to use power tools. I have to move them around the stage. I have to teach them how to mic up other students. It is necessary for me to teach and keep them safe. That was his testimony. And so the letter of direction was crafted in a way that allowed him to continue to carry out the curriculum. But you also know what Mr. Power's impression of that meeting was, because he told MCSO. He said, "The school told me to teach from behind my desk." Mr. Power's impression was the school told me to teach from behind my desk. That was his impression of the meeting with Mr. Ridenour. Mr. Ridenour meeting with Mr. Power to understand why it was even necessary to place his hand on students for purposes of curriculum is a reasonable step. What's not captured in that letter is also Mr. Power's understanding of the expectations of teaching behind his desk. Delivering that message and the letter of direction in a way that that was his understanding of what's expected of him, that is also a very reasonable step for an educator to take. And I want to talk further about the letter of direction. As you heard from the testimony, the district utilizes a progressive steps of discipline model. The first step is simple coaching and counseling conversation without a written meeting summary. The next step is coaching and counseling with a written meeting summary. The third step is a letter of direction. You heard testimony from Mr. Ridenour and Ms. Woodworth that the letter of direction isn't really something assistant principals are even tasked with handling unless specifically instructed by human resources. In this case, Mr. Ridenhour was tasked with drafting a letter of direction and delivering it. He did that. The state is taking the position that Mr. Ridenhour should have advocated for something else. Reassignment to home, suspension, termination. Again, this is the first time Mr. Ridenhour had ever dealt with a situation like this. He involved the executive director of human resources, who deals with disciplinary matters. Ms. Woodworth testified that HR handles written reprimands, HR handles reassignments to home with pay, HR handles suspensions, HR handles terminations. Had Mr. Ridenhour not involved human resources, I understand the state, I would understand the state's argument, at least, that, well, maybe he should have gone outside of just himself and gone to HR and advocated for these things. But that's why you involve human resources. That is within their specific scope. But the letter of direction, again, skip step one. This wasn't a situation where Mr. Ridenhour felt it was appropriate for just simple coaching and counseling. He skipped step two of the progressive steps of discipline. This wasn't a situation where he coached and counseled with a written meeting summary. Instead, he issued the letter of direction. And why? The letter of direction, once sent to human resources, goes in the employee's personnel file. As anyone who works in education knows, the personnel file is a matter of public record. It's maintained for the duration of that person's employment and thereafter. Anyone and everyone could obtain a copy of that letter of direction and understand what the issues were. The state takes the position that, well, there's not really a mark on his record. That is a mark on his record. It's a document maintained in his personnel file. Sending the letter of direction to human resources to make sure it was maintained in his personnel file as is appropriate was also a reasonable step. Visits to the classroom. Mr. Ridenhour visited Mr. Power's classroom on several occasions. You heard his testimony. This was tryout season for volleyball. Volleyball coach and Mr. Power shared a classroom, and he would visit him several times a week. And his practice was, if he identified anything that was concerning, he would document it. There's no documentation that he identified anything that was concerning. That was also a reasonable step. Mr. Ridenhour also collaborated with others at the district to afford students the opportunity to withdraw from Mr. Power's class if they were uncomfortable. And we know that at least one student did so. Student one. You heard Ms. Woodworth testify today that student one withdrew from the class before the next class period even happened. Student one submitted the written complaint, was withdrawn immediately, and enrolled in a dance class within the same week that she submitted the written statement. Affording the students the opportunity to withdraw from that class if they were uncomfortable is a reasonable step. The call to the parents. If you'll recall, student one's witness statement has some writing on it on the top right-hand side that says, call mom. Mr. Ridenhour's testimony was, I wrote that to remind myself to call mom. And my recollection is, I called the mom. Student one's mother didn't answer. So I sent student one home with a business card and said, have your mother call me, please. That is a reasonable step to inform the parents of what is going on. The mental health services that were discussed by the state. Counselors in the district are not mental health professionals. Mr. Ridenhour testified that it was his understanding that others within the district were going to provide any support and resources that they could. You heard Ms. Woodworth testify this morning that one of the counselors that she supervises, Ms. Glascom, did in fact reach out to student one. You also heard Ms. Woodworth testify that the district's mental health professional with the district office also reached out to the parents of student one, and that those services were rejected. I also want to highlight the timing of all of this and just identify this isn't a situation where Mr. Ridenauer sat on his hands and did nothing. If you review the student statements, you'll see that they are dated February 9th of 2021. Mr. Ridenauer collected those written statements, the rest of them for the students that had not already completed written statements, on February 9th, 2021. He acted the same day to go get those written statements. Attached to one of the written statements is an email from one of the students' parents. You heard Mr. Ridenauer testify that he asked for additional evidence related to Mr. Power. And one of the parents responded the same day, February 9th, sending additional text messages to Mr. Ridenauer that could be considered as part of this process. First thing in the morning on February 11th, 2021, was when the meeting occurred between Principal Phillips, Mr. Ridenauer, Officer Lyons, Dr. Falloon. That is the meeting in which they called in Miss Woodworth and said, can you go meet with these one or two students, please, and see if there's any other information that you can elicit? Meeting happens on February 11th. They call in Miss Woodworth on February 11th. If you look at the letter of direction, the date of that letter of direction is February 11th, 2021. So not only did that meeting between Dr. Falloon, Mr. Phillips, Mr. Ridenauer, and Officer Lyons happen on February 11th, 2021, what else happened? The letter says, based on our conversation this morning, we know that shortly after that meeting at 8:30 on February 11th, Mr. Ridenauer then went and met with Mr. Power to ask, why in the heck are you touching students at all? Tell me how that's related to curriculum. By February 12th, the student one had been withdrawn and re-enrolled in a different course within the school. She was immediately withdrawn from Mr. Power's class and enrolled in a different course. On February 16th, 2021, which is after a weekend, Mr. Ridenauer then sent the letter of direction to the district's executive director for human resources so that document could be stored in the employee's personnel file. All of that happened within 1 week. This is not a situation where an employee sat on their hands and did nothing. Everything I just outlined for you is a reasonable step. And those steps were done promptly based on the timeline that we know. You also heard the state board testify that employees, based on their own training, can proceed through the progressive steps of discipline without reporting to the State Board of Education. It's in the training that we just went over. This is a case where the state is seeking to win at all costs. And I would direct your attention to paragraph 50 of the complaint. If you'll recall, paragraph 50 of the complaint identifies Mr. Ridenauer as someone who snuck onto the campus of student one and confronted her. If you recall the video we watched at the end of the last hearing, Mr. Ridenauer was wearing a polo and khakis. He was carrying flowers to his wife. But the state still sought to categorize him as someone who was on campus that day for purposes of confronting student one. The video evidence clearly demonstrates that that is false. What else is false? What else do we know is false? The state also seeks to identify Mr. Power as someone who may have gone on to work for another school. We know that's not true. Exhibit 14 is the intent to retire from the district. Mr. Power identified that he was retiring. Exhibit J is the ADE information that identifies, in fact, that Mr. Power did not go on to work for any other school or any other district. His employment history, according to ADE, ends with his employment from Chandler Unified School District. The state is also seeking to identify the actions or inactions of other And that was clear from the closing that the state just offered the committee. The state offered they, the school, the district. Careful review of the complaint will also identify others. Mr. Phillips, Dr. Gilbert, Dr. Falloon. None of them are before the committee today. The committee should only consider those items in which Mr. Ridenour was involved. Mr. Ridenour's involvement is limited to the February complaints. We know that from his testimony. He wasn't involved in receiving the March complaints. He wasn't involved in the Title IX process. He wasn't involved in Mr. Power's retirement from the district. He wasn't involved in the Title IX appeal. Nothing in the police reports even identify that they tried to contact Mr. Ridenour. Mr. Ridenour testified that no one tried to contact him. His involvement in this matter is limited to just those February complaints. There was also conversation in the state's closing that, well, Mr. Ridenour could have called Officer Lyons to the stand and offered his testimony for the committee's consideration. I would submit that the state had that equal opportunity, and yet only one party of this matter attempted to subpoena Officer Lyons to appear and testify before the committee, and that was Mr. Ridenour. Finally, a point that I think is worth the PPAC's consideration. At the end of Mr. Ridenour's testimony, he expressed his perspective of this case. He also expressed remorse that he always tries to do right by students. That's what he tried to do in this case. He tried to do right by students. He also expressed that this case isn't just about him. It's about other educators that might be in that chair, where there's no mandatory duty to report, an educator dealing with a situation for the first time, following the chain of command, using the tools within the scope of their authority to take action. Again, this was not a situation where an educator sat on their hands. I want to revisit Hearing Officer Lee's comments at the start of this hearing today, which was that the state bears the burden of proof as to all matters. It is the state's obligation to prove by a preponderance of evidence the allegations against Mr. Ridenour. It is not Mr. Ridenour's obligation to prove his innocence. But if we look at the facts and circumstances of this case, and the laundry list of items that I just went through, that Mr. Ridenour took to try to solve this situation, I think the answer here is clear. Mr. Ridenour took reasonable efforts to protect the health, safety, and well-being of students. He did not engage in conduct that would discredit the teaching profession. I and Mr. Ridenour would request that the committee find that he did not engage in unprofessional conduct and that he should not be disciplined. Thank you.
I have just a few rebuttal comments.
I'm sorry.
I have just a few rebuttal comments.
Yes, sorry.
Yeah.
Go ahead.
Let me start with this. Follow up with the other 10 students that were never contacted. It took, you'll see, every single one of those first 5 reports were taken on the same day. They were all taken on February 9th. That's corroborated by the testimony. And if you look at the reports themselves, it took exactly one afternoon. That's it. For Mr. Ridenour to talk to all 5 of those students. Had he contacted the other 10? Spent about the same amount of time? A day, perhaps? If he had split that up amongst his principal, Miss Woodworth, anyone else, could have been done in again in another half a day. The suggestion that the state is somehow arguing here that everything and anything has to be done. It's just not true. That's a very minimal effort for a very important issue. Number 2, I wanted to remind the members of the committee when counsel is arguing to you that, boy, Mr. Ridenhour was in that classroom a whole bunch of times, and he testified that if he saw anything, he would have documented it. And since he didn't document anything, I guess he didn't see anything. You'll recall when I was examining Mr. Ridenhour, I had to do what we call impeachment in the law. It's going back to prior testimony that he had given, testimony where he had appeared before the PPAC in his prior hearing, where he had sworn under oath to tell the truth, and where he was asked these questions. And the questions that I had asked him, you'll recall, are, did you visit his classroom after you had started your investigation in February of 2021 to observe him teaching students? He said that had happened. You mean between, well, tell me about the timeline you're talking about. I asked, between the time you handed him a letter of direction and the time that he ultimately left the school. His answer, I had not been in the classroom. The next question was, so let me just clarify that. I think what you said was, quote, I had not been in the classroom, end quote. His answer was, I had not been in the classroom that I recall. My next question was, so were you or were you not monitoring him personally after you gave him the letter of direction? Answer, I was not. Let me finally go back to this issue about each and everything. How about telling your principal, I don't think this letter of direction is enough. It's not each and everything. How about telling your HR director that, you know, I'm wondering if we shouldn't do something more to finish this investigation or to protect these students. That's not each and everything. Or how about when you're cruising around the school to go talk to your volleyball coach or others, you take one day, just one day even, and you stop into Mr. Powers' classrooms and you follow up and you let him know that we are monitoring you. That's not each and everything. The state is not contending that every minute of every day after this incident had to be consumed by Mr. Ridenhour with just dealing with Mr. Power. But you do have to do what you can do, what you can do reasonably, and what you do in other circumstances to protect your students. The type of things that Mr. Ridenhour didn't do. Thank you.
Thank you. Having heard the testimony and reviewed the evidence, the committee will now discuss the case. Does the committee need a break? Okay, let's take, let's see, it's 1:20, 1:25. We're back on the record at 1:25 PM. Does committee want to have discussion before we turn to two sets of findings of fact?
Yeah.
All right, Mr. Scholl.
Couple things I want to mention. It concerns me that in the state's documents, they have 48 different items that they talk about that is transferred to the findings of fact. 23 of them, 1 through 24, kind of apply during Mr. Ridenour's time, his involvement in what went on. Numbers 25 through 47 are after March, when he wasn't even involved. And number 48 is the time that he was at the school, that I think the video showed doesn't corroborate what the student or what it actually says in there. And so that concerns me. And I was an assistant principal for 6 years. That was about a little less than a quarter of my career, about 20% of my career. And I can see myself doing exactly what happened. And it's concerning, and I'm glad that Mr. Power is no longer in the profession, hindsight being 2020. But that initial contact with them, and the letter of direction, and the contacting of the students, and offering the students what they did, I could see that happening. And I think that could be considered reasonable. Now I'll leave it at that.
Other discussion?
If I could.
Yes, Mr. Embo.
When you make the choice to cross that aisle from teacher to administrator, the responsibilities grow demonstrably, and you know that going in. You're tasked with creating and maintaining a safe learning environment. You're to advocate for students while balancing the due process of teachers. A couple of things that I pondered throughout this. Was this investigation conducted for expedience or thoroughness? Why were the students that were interviewed originally, there were other students that were referenced, why weren't they additionally interviewed for more information? The term chain of command came up on several occasions. Mr. Ridenour used it back on day one of this hearing. It was also alluded to by Ms. Woodworth, as well as defense counsel today. And my question on that is, when you talk about chain of command, does turning over a matter to a superior absolve you from additional scrutiny? And I'm always fearful when is chain of command it should not be deployed as a matter of convenience, but as a methodology for problem solving to get to the best possible decision via discussion.
Thank you. Ms. Talton, I believe you were going for the microphone.
Yes. In reference first to document 1 that member Scholl brought up, well, if I were to make a motion on whether or not to use document 1 or document 2 for our findings of fact, I would choose document 1. I agree with paragraph 48. I don't think 48 is necessary for what we're called to do today. And I understand your reasoning or your ideas about the other paragraphs. However, the reason I think they need to be included is because what they do point to is the harm that resulted because of the limited action that was taken. And so I think that they're necessary. 48 would be the only one that I would be okay with omitting. And ultimately, since we're having the discussion, children were harmed in this situation. I think this is my 8th year in this position. And so I've heard a lot of cases. This is my 22nd year in education. I have assumed many roles on campus, from leadership, teacher, mental health provider. And as I have gone through this case multiple times, all of these pages, I keep coming back to the same thing. Children were harmed. That is evident. That is clear. Everybody can agree. Children were harmed, and not enough was done to correct that harm. And I think the inaction is what caused the residual harm. And I can't be a part of continuing that idea. And so I disagree that reasonable efforts were made to protect the student. And because of that, there is a discredit to our teaching profession. I think public trust was broken. And just as an individual sitting on this committee, I can't participate in the continuing of the harm. And and so I think all in those first 47 are important, because omitting the what happened after is a participation of further harm of students. So I'll leave it at that for now.
Dr. Klinick?
You said that very well. So numbers 1 through 47 were the ones that I was looking at as well. 48, it's important, but I don't think it's necessarily applicable to this case. For something that you mentioned being an assistant principal for 6 years. I was as well. And if it were a rookie mistake, as you might say, that would still be a problem, but he wasn't new to the profession. He was not new to the role. He'd been in that position and has substantial experience, and I don't think it's I think it's something he should have been able to address more thoroughly. Also, I want to talk about the letter of direction, because that's kind of bothering me. So a letter of direction, I've been in 3 school districts. It's always been administrative, not disciplinary. As an administrator in 3 districts, I've never experienced where that actually goes in the file. So it's noted, HR might review it, but it does not typically go in the file. That's a letter of reprimand. So at least in all of my experience in 3 districts. Also, in the letter of direction, it does state that it could be considered grounds of dismissal. So I'm not sure why that's being overlooked as well. So if it's severe enough where that's even put in the letter of direction that it could be grounds for dismissal, why is it only a letter of direction? And then I also agree that there is that mental harm that was happening towards students, to the point where it was testified earlier that one student actually had recommended counseling. So if we need counseling, we need classrooms changed. How is that not harm towards students? That's recognized in February. Thank you.
Thank you. Further discussion?
Yes, I do.
Yes, Ms. Alonso.
I was going to focus on that mental health piece in particular for these children, because we are talking about children, and what message we're sending these girls. As we know, there were no male students that came forward. They were all female students. And statistically, we're looking at roughly 1 in 3 women nationally who are harmed in some way or another, or touched inappropriately, or victims of unwanted touch. We're also looking at a roughly 80% of women who don't report, simply on the basis that they're not believed. And I feel as though I cannot be a part of furthering harm in the way my colleague, Member Alonso said, or Member Hilton said. that contributes to girls not reporting things that have happened to them out of a fear that they're not going to be believed once they're reported. And then there is also a high re-victimization statistic that goes along with anybody who is a victim, that they will never report it because the adults failed. And I can't be a part of a decision where that is overlooked or not considered because they do not get the privilege to say this was 5 years ago and I don't remember. You're asking me to recollect something 5 years ago and I can't remember. They're going to remember every time that they did not want to be touched and were. And they don't have the privilege to forget what the adults' faces looked like, who did not follow through the way that things should have been followed through on.
Thank you. Further discussion? Right. You have been presented with 2 sets of proposed findings of fact, conclusions of law, and recommendation. Vice Chair Helton referenced document 1, and as did Member Scholl. But you also have document 2 to consider in front of you. So if there's no further discussion, I will entertain a motion from either document.
I move that we use document 1, the state's proctored proposed findings of fact and conclusions of law for the rest of our proceedings.
A second.
Okay, it's been moved and seconded that you use document 1 for the rest of your proceedings. Is there discussion? All in favor?
Aye.
Aye.
Opposed?
Aye.
I'm sorry.
Opposed.
Thank you, Member Shaw. I did not mean to exclude you.
Right.
The motion carries. So the committee is using document 1. Is there a motion concerning the findings of fact?
I will.
Helton.
I will move to include, let me go back up, the findings of fact, numbers 1 through 47, and omit number 48, paragraph 48.
Is there a second?
I second.
It's been moved and seconded that the committee use findings of fact 1 through 47 on document 1, omitting number 48. Is there discussion? All in favor?
Aye.
Aye.
Opposed?
Aye.
The motion carries. In document 1, the state has presented aggravating and mitigating factors for you to consider adding to the findings of fact. Are there any aggravating factors the committee would like to add to the findings of fact?
I move
Dr. Klinick.
to add aggravating factors, F, vulnerability of the victims, and G, substantial experience in the field.
Is there a second?
Second.
Thank you. It's been moved and seconded that the committee add aggravating factors F, vulnerability of the victims, and G, substantial experience in the field. Is there discussion? Hearing none. All in favor?
Aye.
Aye.
Opposed? The motion carries. Are there mitigating factors you would like to add to the findings of fact? Hearing none. In document 1 are conclusions of law for you to consider. Is there a motion concerning the conclusions of law?
I move that the PPAC accept the conclusions of law 51 through 57 as presented.
Is there a second?
Second.
Thank you. It's been moved and seconded that the PPAC approve conclusions of law 51 through 57 as presented. Is there discussion? Hearing none, all in favor?
Aye.
Aye.
Opposed?
Aye.
The motion carries. The final issue for discussion for the committee is the committee's recommended order to the Board of Education. The committee may consider any of the following actions alone or in combination pursuant to ARS Section 15-203A. Take no disciplinary action against the respondent. 2, issue a letter of censure to the respondent. 3, suspend all certificates for any length of time up to 5 years. 4, suspend the certificate and impose conditions. 5, revoke any and all certificates held by respondents and that all states and territories be notified. Is there a motion concerning the order to the Board of Education? Ms. Halton.
Based on the foregoing findings of fact and conclusions of law, the PPAC recommends that the board take disciplinary action through a 3-year suspension to start after the end of the respondent's current suspension, and that any and all certificates, and that all states and territories be so notified.
Is there a second?
I second.
It's been moved and seconded that based on the foregoing findings of fact and conclusions of law, the PPAC recommends that the board take disciplinary action through a 3-year suspension to start after the end of respondent's current suspension. Is that correct?
Mhm.
And of any and all certificates held by respondent, and that all states and territories be so notified. Do you want me to try that again?
I think you got it.
Okay. Did I get a second? Thank you. Thank you. Is there discussion? Hearing none, Ms. Stolro, please call the roll.
Vice Chair Helton,
Excuse me, I vote aye, with explanation can be taken from my discussion at the beginning of our deliberation.
Member Alonso,
Aye.
Member Ambos,
Aye.
Member Dr. Clinic,
Aye.
and Member Scholl.
Nay. And with the same caveat, my vote is based on the conversation that we had at the beginning of this, at the discussion.
Hearing Officer Lee, you have 4 ayes and 1 nay.
Thank you. By your vote of 4-1, based on the foregoing findings of fact and conclusions of law, the PPAC recommends that the board take disciplinary action through a 3-year suspension to start after the end of respondent's current suspension of any and all certificates held by respondent, and that all states and territories be so notified. This concludes the formal hearing. The committee's decision will be reduced to a written recommendation and delivered to the Board of Education. The board will make the final decision. Each party will receive notice of the board meeting at which it will consider the committee's recommendations. The parties will have further appeal rights that will be explained in the final order issued by the Board of Education. Thank you for your attendance today. Is there a director's report?
Hearing Officer Lee, there is not a director's report.
All right, we are concluded and adjourned.
Get ready to relax with stress-free banking at Credit Karma.
Feel the tension melt away with a checking account that's 100% free to open.
Cha-ching.
And experience the pure euphoria that only a high-yield savings account can deliver.
Start your financial self-care routine with Intuit Credit Karma today.
Bauer Tools give you the confidence to take on challenging home projects. With hundreds of corded and cordless tools and accessories, Bauer is ready to deliver. Whatever you do, do it for less. Only at Harbor Freight.
I think we should look at this chart. This chart shows the budget of the U.S. government agency called Immigration and Customs Enforcement, or ICE. You can see that they're pretty well funded, around $10 billion a year. I looked up this chart because ICE has been in the news recently.
ICE agents detained some 1,600 illegal migrants on Tuesday.
Raided this meatpacking plant.
Rounding up workers.
20 to about
more than 100 people
detained without explanation.
Put into handcuffs.
And taken to detention centers.
ICE is a kind of immigration police. And long before Donald Trump, at the very beginning of when ICE was created in the early 2000s, the agency had a very ambitious goal: to deport everyone they possibly could, to, quote, remove all removable aliens. They share the same parent agency as Customs and Border Protection, which focuses on the border. ICE focuses on all of this: the interior.
Immigration and Customs Enforcement officials wasting little time under the new administration.
Arrested nearly 1,200.
Large-scale immigration
Building was surrounded by federal agents.
Different targets on this
immigrants
one.
detained over this past
9 single adult females, 4 female heads of household.
5 members of his congregation detained.
And if you look at this line, you will see that indeed ICE arrests have spiked since Trump took office. And a big way that the new Trump administration has sold this surge in deportations is crime.